Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Hello everyone, I'm here today and we're going to go through a lot of information. So recently the motion of Limine, well, however you want to pronounce it, I've heard it all ways, has come out from the prosecutor on the Delphi case. These motions are very common. Normally, you don't hear about them unless it happens during the trial. Then you might. But as you're watching the trials, this is all done behind the scenes. Normally there's a quick hearing before the trial. The prosecution or the defense puts in their motion of limine, and they normally have a hearing on it, hash it out, judge makes a decision, and they go into trial. That's not always the case, though. It can also happen during the trial. And you'll see that here in just a minute. I am going to share my screen here because I do want to give you a little bit of background on what this is. Okay. So what is a motion of limine? It's a motion filed by a party to a lawsuit or a court case, which asks the court for an order or ruling limiting the preventing certain evidence from being presented by the other side at the trial of the case. Okay, so this can happen by the prosecution, the defense, or both. Generally, this motion is filed in advance of the trial, but a motion may be entertained by the court during a trial, before the evidence in question is offered. Okay, so what does this mean for the Delphi case? Well, as we all know, Judge Gall, she doesn't like to have these hearings. She likes for the prosecution and the defense to put in their motion, the other side to put in their thoughts and feelings on the motion, and then make a decision. Is that going to happen in this case? Probably. I don't see her with 12 days before a trial having a hearing and hashing this out. I think she's going to go by their briefs and she's going to make a decision and we're going to go from there. But today, I'm going to read the motion of limine from the Delphi case, and I'm going to read the motion of limine from the Tabitha Shuck Raines case, because I want you to see that these are common. Okay, I've heard a lot of YouTubers say, well, they're basically, the prosecution is telling the defense that they can't use what's called a third-party defense. Well, they can still use a third-party defense. And we're going to see a perfect example of that today in the Karen Reed trial. The defense in that trial did phenomenal on their opening statement. And they are using a third-party defense And I can guarantee you a motion of limine was put into that case. And I'll explain all of that later. Okay. I gotta find my screen here. I just want to give a little bit more information on what this motion is, because it's important. Okay? The purpose of this motion is to prevent the interjection of matters which are irrelevant, inadmissible, or prejudicial. Most objections to the admissibility of evidence are made when the evidence is offered at trial. Thus, the jury usually hears the question and the witness answer before the objection is made, or hears the other lawyer discuss the evidence in his opening statement. The reason these motions are filed in advance of the trial is to prevent the other party from offering the evidence in front of the jury. Okay, so that's really important in these trials. It stops both sides from stating certain things. Once the evidence is offered, the cat is out of the bag and cannot be put back in, which means if you're a jury and you hear all of this, you're going to take it into consideration whether you're told to strike it or not. Okay. The other thing that I want to talk to you about is the prejudice rule, because this is the one that's really going to affect this case. Rule 403 is known as to all lawyers as the prejudice rule. It says that relevant evidence may be excluded if its probative value is substantially outweighed by any of the three effects that detract from a fair trial: unfair prejudice, confusing the issues or misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. In order for a danger to be substantially outweighed probative value, the probative value must be pretty small, i.e., be of little or no relevance to begin with. You can't exclude evidence that a child was abused as unfairly prejudicial if the defendant is on trial for that act. You can't argue that calling 5 witnesses to describe the same thing is a waste of time if they're describing the event itself. Determining probative value is at the discretion of the judge. In general, it is determined by the factors we discussed. How logically related is the evidence to the key disputes? How important is the issue to the resolution of the case? How necessary is the evidence? How much other evidence with lower prejudicial effect has already been introduced or will be introduced? Remoteness. How far removed in space and time from the people, places, and events being litigated? Okay. Rule 403 is most often invoked to object that evidence is too prejudicial to be admitted. Determining prejudicial effect of the evidence is also at the discretion of the judge. In general, it means the extent to which information arouses the emotion of the jury, such as sympathy, bias, or hostility, thereby interfering with the ability to reach an impartial verdict. Whether the emotional impact is fair or unfair. Emotionalism is fair if it's a part of the case, and it's unfair if it's outside the facts of the case. For example, evidence of a child abuse is always emotional, but whether it is unfairly emotional depends on the case. If the defendant is charged with child abuse, the emotional impact is an inherent part of the trial. But if the defendant is charged with burglary, getting the jury all riled up about child abuse is unfair. Whether the evidence involves some subject likely to get church-going folks all upset, such as sex, drugs, and rock and roll. Whether the information will come as a shock to the jury or they already know about it. Whether less prejudicial evidence is available. Rule 403 mentions two other dangers that warrant the exclusion of minimally probative evidence. Confusing the issue or misleading the jury arises when evidence is relevant to two or more issues, one of which is relevant and the other is not. We worry that the jury may become confused as to what the issues are and may return a bad verdict because of it. For example, if a plaintiff sues two defendants and one settles, it will be the judge's job at the end of the trial to reduce the verdict by the amount already paid. So introducing evidence that a co-defendant admitted fault and paid damages would confuse the issues that are properly before the judge. Waste of time. It's also potential ground for exclusion. This rule is rarely invoked by attorneys, but gives a judge discretion to cut off relevant testimony that has become boring and protracted. If the crime were committed in front of a law school class and the prosecution subpoenaed all 120 students, after about 15 have testified, the judge is likely to run out of patience. Okay. So that is all that I wanted to read from that document. Now, I'm just going to take a look here to see what people are saying. Hello down under, welcome. Andrea, thanks for my mods being here tonight, you two. Camaro Lover, hello. Gloria, hello. Jean Williams, hello. Under the Scars, welcome. Serenity Snay, hello, how are you? Let's see here. Serenity Snay, let's be respectful to my mods and in my chat, or I will not hesitate to remove you. Let's see here. CJK, how are you? Yes, be respectful in the chat or you will be put in timeout and banned. Hey, Lollipop, how are you? Your comments towards my mod and being, including Pooh, are disrespectful. We can all be adults here and disagree, as long as you do it respectfully. Okay. We are going to get into the motion of limine for the Delphi case. And what does it say? what is asking to be excluded. So I just want you all to know that the things that are in this document don't surprise me one bit. Not one bit. So that is your copy to see. So it says State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen. Motion in limine. Now comes the State of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully requests that the court enter an order required the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing arguments. Any and all references to the following, either directly or indirectly. Number one, any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state's attorney. Johnson versus state. Craig versus state. Flynn versus state. Basically, don't say bad things about the prosecution during trial. Number two, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. Plain as day. Number three, any innuendo or reference that is not supported by admissible evidence. That's important. We're not putting the Odinist on trial. We are putting Richard Allen on trial. Number four, any attempt to indoctrinate the jury during voir dire by exposing the jury to substantiative issues in the case. We just heard about these substantiative issues. Number five, any attempt during the voir dire to have a judge prejudge the credibility of a witness. So basically, the defense teams can come in and say, well, we were going to have this witness on, but the judge won't let us. Any hypothetical questions that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. Before any such evidence may be permitted, the defense must show some connection between third party and the crime. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. The state requests such orders in limine to include, but not be limited to, the following: Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Mezzer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, Ron Logan. Any reference to an investigation conducted by Todd Click, along with any reports or investigative material from Todd Click that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. One second. Okay. Burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. Any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issue. Any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for. That's important, you guys. The defense team just can't throw theories and stuff out there and bring in all this stuff when it doesn't pertain to what Richard Allen is on trial for. And it says that is not an act that is an exception to IRE 404B, and that is not both relevant under our IRE 401 and tended to negate the guilt of the defendant. Any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issue. So basically, let's say I come up with some crazy name for a document, and that's how I save it. The defense isn't allowed to say anything about that name of the document. It has no relevance in the trial. Any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German that are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Once again, you can't bring in all of this crud that doesn't pertain to the case. Just because the police went and investigated it doesn't mean it has any bearing on the trial against Richard Allen. Okay. Says, wherefore the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests the court to grant the following relief. A. Order the defendant, through his counsel and witnesses, to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. To further order said person to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper in the premises. This is why we don't hear about these motions in the trials. You're not allowed, as a defense attorney or a prosecutor, to say, well, the defense team has tied my hands because of the motion of limine, or whatever, that doesn't allow me to say certain words or certain theories or bring in other information. And the judge ordered that I wasn't able to do that. Can't do that. It's an automatic prejudice. Okay. All right. I'm going to close that up. Now, we read the Limine issue for Richard Allen. Thank you. I was brought food and drink. This is, and I'm going to try to get it big. This is the motion for Limine in the Tabitha Shuck Raines case. Oh, Ron, Serenity is only 15 or 16 years old, huh? Okay. State of Indiana, County of Hamilton, State of Indiana versus Elizabeth J. Balser. State's motion for order in limine. Now comes the State of Indiana by J.D. Rich, prosecuting attorney, 36th Judicial Circuit, and before trial and selection of a jury, respectfully requests the court to issue an order in limine prohibiting the defendant, her counsel, and any other defendant witnesses from mentioning either directly or indirectly by statement, question, or otherwise any of the following items during the trial of this cause while the jury or prospective jurors are present. Number one, any statement suggesting any motivation or rationale on the part of the Tipton County Prosecutor's Office in seeking any penalty or result in the prosecution of this matter. Sounds kind of familiar, huh? Any evidence of other crimes, wrongs, or bad acts sought to be admitted to prove the character or conformity therewith of any person, whether or not the person is called as a witness in this cause, including any and all evidence of any physical confrontations, fights, or arguments between and involving Andrew Bush and any defense witness or anyone else. Any and all evidence of a statement made by Andrew Bush to Jason Jackson, Matt Clauser, Josh Nantrup, and others at Jackson's trailer regarding Tabitha Raines' disappearance. Any and all evidence of use, distribution, or supplying of morphine patches or any other controlled substance by Andrew Bush and or his father, Leroy Bush, except for drug use on October 2nd, 2002 by Andrew Bush. Why is this so important? Well, the key witness in the case supposedly testified for the prosecution in order to get his dad out of trouble for a death that these morphine patches caused. D. Any and all evidence of a purported conversation between Andrew Bush and Rhonda Epp, purportedly taped by Epp, regarding Elizabeth Balser and Andrew Bush's eyewitness account in this matter. Any and all evidence regarding a tattoo party in the year 2000 where Andrew Bush, Tara Shuck, and Tabitha Raines were all present, and an argument purportedly took place between Andrew Bush and Tabitha Raines regarding Raines' sister Tara Shuck. Any and all opinion testimony by Jason Jackson, Jared Hearn, Matt Klauser, or anyone else suggesting Andrew Bush liked Tabitha Raines more than just friends, that Andrew Bush's overtures towards Tabitha Bush were rejected, and that as a result, Andrew Bush was upset with or mad at Tabitha Raines. Any and all evidence concerning a purported dispute between Andrew Bush, Brian Bowen, and Anthony Edwards regarding rental of and alleged damage to a mobile home in Windfall-Tipton County, Indiana, in the summer of 2002. Any and all evidence regarding a purported conversation between Amanda Pratt, Neff, and Michael Raines before Tabitha Raines was killed, where Michael Raines supposedly told Pratt, Neff, he had to get out of his marriage with Tabitha Raines, but divorce was not an option in doing so. Any and all evidence concerning a purported conversation between Chris Abney and Michael Raines after Tabitha Raines' death involving Michael Raines' desire to get out of his marriage to Tabitha Raines. Any and all evidence concerning the death of Shane Jackson, the death of friend of Andrew Bush's in Illinois, and the overdoses of Matt Klauser and Brian Bowen, all of which involved the alleged use of morphine patches. Any and all evidence concerning extramarital affairs engaged in by Michael Raines during his marriage to Tabitha Raines, as well as a sexual encounter shortly after Tabitha Raines' death between Michael Raines and a mistress. So, basically, in this case, it was okay for the prosecution and the defense to basically say that Tabitha Raines was having all these extramarital affairs and running around with different men, sleeping with different men, but they could not state that the husband was doing the same thing and wanted to get out of his marriage. Any and all evidence concerning sexual encounters and or relationships with other women Michael Raines was involved in after the death of Tabitha Raines. Any and all evidence concerning a purported ongoing extramarital affair between Kyle Neff and Tabitha Raines in the months preceding the death of Tabitha Raines. Any and all evidence concerning a sexual tryst involving Kyle Neff, Amanda Pratt Neff, and Tabitha Raines in the spring-summer of 2002. Wow. Okay, so they're not allowed to talk about any of that, even though it could go towards motive in her murder. And this is from the prosecution. Any and all evidence concerning purported threats made to Kyle Neff and Amanda Pratt Neff by a drug dealer in Indianapolis named Tabby over allegations Kyle Neff ripped Tabby, the drug dealer, off in the summer of 2002. Any and all evidence or testimony provided by Tiffany Boatwright, Amber Heaton, or Emily Brown regarding a purported conversation involving Boatwright, Heaton, Brown, Kyle Neff, and Amanda Pratt Neff at Neff's house after Tabitha Raines' disappearance and before the discovery of her body, wherein Boatwright, Heaton, and Brown stated Neff and Pratt Neff acted suspiciously. They heard dragging noises before they were finally let in the house, and Amanda Pratt Neff purportedly said, "I hope Tabitha is found okay, but if we cross paths, I'll kill her." Any and all evidence concerning conversations in 2003 between Michael Raines and a girl named Ashley, or April Lee, wherein Michael Raines purportedly stated, "I know more than anyone, even the police, about what happened to Tabitha." Any opinion evidence offered by any person as to the propensity of Andrew Bush for violence. So basically, this prosecutor didn't want the defense to be able to state anything or prove anything about how their main witness was violent, drugged out, was doing this to get his father out of trouble. I mean, it's ridiculous. And this was all approved by the judge in this case. Any evidence that any person connected with this case has been offered to take, or been tested by a polygraph examination, which includes the results of any polygraph examination. Well, of course, you didn't want it to come out that Michael Raines lied on his polygraph. You didn't want it to come out that Andrew Bush lied on his polygraph. You didn't want it to come out that Jonathan Yates passed his polygraph, because you were trying him. Any statements concerning the penalties or potential penalties for the offenses charged. Wherefore, the state would assert that such evidence stated above would be immaterial and irrelevant to this case, that the introduction of said evidence would be contrary to the state and case laws of the state of Indiana, and that such introduction or mention of evidence would be highly improper and prejudicial to the state of Indiana, even if the court were to sustain an objection and instruct the jury not to consider such evidence for the purpose of this trial. And further, the state of Indiana requests that the court instruct the defendant and or her counsel and or witnesses not to mention, refer to, or otherwise attempt to convey to the jury in any manner, either directly or indirectly, the above mentioned matters without first obtaining permission of the court, outside the presence and hearing of the jury, and further to instruct the defendant and her counsel and witnesses not to make any reference to the fact that the motion has been filed and granted, and for all other relief proper in this premises. J.D. Rich. So, by showing and sharing that with you, there were things that wasn't going to stop what happened in the trial with Elizabeth Balser. Okay, she was acquitted. Absolutely. The jury got it with the evidence that was given at trial. The prosecutor did not prove his case. They did not believe his witnesses, even though all of this other stuff could have come in. Right? So now we talk about, how do you put on, if the judge grants this motion of limine, how does a defense team put on a third-party defense? Well, it can still be done. It's being done this week in the Karen Read trial. Let me get this pulled up. I am not going to show you the prosecution's opening statement. I think it was horrible. Their opening statement was just absolutely horrible. Okay? And if Nick McClellan wants to do better, go watch that opening statement, Nick. Do not do what they do. Okay. I need to stop sharing and reshare because I need to make sure that the sound is on. Otherwise, you'll just be watching the screen. We're going to watch this. It's 39 minutes, but we're going to stop and talk about things. And I'm going to explain how the defense is doing this without, or how Baldwin and Rossi can do a third-party defense without mentioning Odinus, ritual sacrifices, the other Odinus names, Ron Logan. I mean, things like that. Okay. Let me just get this going here.
Karen Read was framed.
Okay, here we go.
Karen Read was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was...
All right, right off the bat, he's bringing in a third-party defense strategy, stating that she had nothing to do with this and that somebody else did. Hasn't mentioned names or anything like that because he's not allowed to, because a motion of limine a hearing was already done on this case, and he's been told what he can say and what he can't say.
No accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Read was framed for a murder she did not commit.
Now, for some reason, he mentioned the Alberts, law enforcement family, right? Perfect. get the jury thinking about a third party that could have been responsible for this man's death. Apparently, in the motion of Limine, he's allowed to mention their names. Nothing was put in there stating he couldn't.
Good morning again, ladies and gentlemen. As I previously told you, my name is David Yannetti. I'm an attorney with an office in Boston. Together with attorneys Alan Jackson and Elizabeth Little, it is truly my privilege and my honor to represent Karen Reed during this trial. From a very early juncture in this case, you will question the Commonwealth's theory of the case. You will question the quality of the Commonwealth's evidence. You will question the veracity of the Commonwealth's witnesses. And you will question their shoddy and biased investigation, a faulty investigation that led to Karen Reed sitting here today.
Does that sound familiar? This case links up with the Delphi case in a lot of ways. Okay? They're blaming law enforcement for not doing their job.
You will learn, in short, that the police did no real investigation of this case, and you will question why. You'll question why the investigators had such tunnel vision. You will question why they focused solely on Karen Reed, someone with no ties to the Canton Police Department, as opposed to the well-known and well-connected Albert family of Canton, a family that was never treated as suspects by the investigators in this case.
You can almost take this guy's opening, okay, and insert Richard Allen's name and other names into it. Okay? I'm telling you, this guy did a brilliant job on putting on an opening statement for the jury on a third-party defense, even with a motion of limine in place, just like the Delphi case. So if you're listening to other YouTubers or podcasters stating, oh my God, this means the defense can't put on a third-party case, they're wrong. This is the way you do it. Let's listen some more.
Boston police officer John O'Keefe was found mortally injured on Brian Albert's front lawn. His body was in full view and almost right below Brian Albert's bedroom window on his front lawn.
Abby and Libby were found on Ron Logan's property, just down some steep hills, 50 feet from the base of the creek. Sound familiar?
He was found wearing only one sneaker. You'll learn that Brian Albert was a Boston police officer as well, and that he was a trained first responder. Brian Albert was notified that another police officer was injured and unresponsive on his front lawn, and Brian Albert did nothing. His sister-in-law, Jennifer McCabe, and other civilians were on his property that morning after John O'Keefe's body was found. Police, EMTs, firefighters, police cruisers, an ambulance, fire truck, lights flashing, and first responder Brian Albert never came out of his house. Equally important for you will be the fact that the lead homicide investigators never went inside the Albert home that night. You'll learn that Brian Albert's brother, Kevin Albert, is a Canton police officer.
Okay, so you've heard what he said. How do you turn it around and put this into the Delphi case? You will hear that others, not naming names, not saying Odinist, had pictures on their social media sites that represented what the crime scene looked like. You see where I'm going here, you guys? Do you see it? I hope so. This can be done by the defense team. Still can be done without mentioning Odist, ritual sacrifices, cults, each one of their names, still can be done.
It was obvious very early on that the Canton police should not be investigating the death of a man found on the property of the brother of a Canton police officer. So it was decided just about from the start that the Massachusetts State Police should take complete control of this investigation because the Canton police were conflicted out. Now, that sounded good at the time, but you'll learn that two major problems arose. First, despite the fact that they obviously had a conflict of interest, the evidence will show that the Canton police still had their hands in this investigation. You will find it astounding, but Canton police officer Kevin Albert, the reason for the conflict of interest in the first place, was continually updated about the status of this investigation while it was going on. Second, and equally troubling, is that the lead state police detective who was assigned to this case was a man named Michael Proctor. Michael Proctor, you will learn, is one of the many people in Canton with deep ties to the Albert family.
Well done.
So what do you guys think so far? Can you see what he's doing without naming names and using the words that he's not allowed to use, but still put on a third-party defense?
His own mother refers to the Alberts as the Proctor's second family. His own sister's wedding, Michael Proctor was in the wedding party with Colin Albert, and he sat at the head table of that wedding with members of the Albert family. That's the man who was chosen to lead the investigation into the suspicious death on the property of Brian Albert. That's the man who gave updates to Canton police officer Kevin Albert while the state police were supposed to be investigating what had occurred at his brother Brian Albert's house.
So, once again, how do you apply this to the Delphi case? The police, law enforcement, had been investigating this for 6 years. They didn't have any viable suspects until Richard Allen came along. However, they did receive information in other interviews alleging that these individuals were at the crime scene or in the area. Exactly, CJK. This is exactly why the jury needs to follow the evidence and understand it. But I'm showing you guys this because it's a proven fact. They've done studies on this. A lot of jurors make up their mind based off of the opening statements. How funny is that? Now, I can't say their minds won't be changed once the evidence is given. And if it's just right there in your face, and goes against what you originally thought from the opening statements, well then, when you deliberate as a jury, other people are going to point that out to you.
You'll learn that right from the jump, Michael Proctor predetermined the outcome of this case. Never stepped foot inside the Albert home on January 29th, 2022. Never checked out whether there were any signs of struggle inside that home. He never called for crime scene technicians and other specialists to look for blood or other trace evidence within the home. He never asked Brian Albert for permission to go in the home and take a look around. Michael Proctor never applied for a search warrant to go in that home. Instead, he...
Okay, perfect thing here. It's telling the jury what the police didn't do. The police never did a thorough investigation on individuals in the community that had made posts on social media that had pictures that looked like the crime scene, or on individuals that stated they were at the scene and left DNA evidence at the scene. See where we're going here? I'm trying to do a parallel between this third-party defense opening and Delphi to make you see that it still can happen.
Focused immediately and exclusively on Karen Reed.
Police finally focused on Richard Allen, and only Richard Allen.
The outsider. You will learn that no one in the Proctor family has ever called the Reed family their second family. No one in the Proctor family had been in a wedding party with anyone from the Reed family. Karen Reed was a convenient outsider. She was most definitely not from Canton. So how did Michael Proctor feel about her? How did he treat somebody he was investigating at a point in time when he should have been keeping an open mind and focusing on obtaining all possible evidence so that he didn't miss anything? Well, you will learn that on the very day that John O'Keefe was found dead on Brian Albert's lawn, Michael Proctor was texting with his high school buddies about this supposedly secret investigation using his personal cell phone.
Okay, so the defense attorney has told you what law enforcement hasn't done, right? Now he's turning over and he's going into what the information is. Okay, it's really important to follow along here, and in your mind, listen to what he's saying and apply it to the Delphi case.
He was revealing information about this investigation to his friends, assuming that nobody would ever find out what he was doing and what he was saying. And he was revealing his true thoughts about Karen Reed to his friends, not what he put in his sanitized police reports, his true feelings. To his friends whom he trusted, and in text messages that he never thought would come into the hands of the defense in this case. Lead investigator Trooper Michael Proctor, right from the start, called Karen Reed names you would reserve only for your worst enemies. He told his friends that he hoped that she would kill herself. He told his friends that he had seized her cell phone. And you will learn that he knew he shouldn't have been accessing any content on her cell phone because he knew there would likely be attorney-client communications on between Karen and me at that time. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway. without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed.
All right, so what are some of the things that the defense team could put in here about Richard Allen? Law enforcement stated that there are witnesses that place him there. But have any of them actually identified that it was Richard Allen there at that location? Richard Allen admitted that he was there and was wearing similar clothing. But most of the men in that area wear that type of clothing. Is it making sense, guys? I hope so. I'm going to play a little bit more of this, just so you get an idea, and then you can go and watch the rest of it if you'd like. I don't want to get in trouble by Court TV. I know that I'm stopping it and talking about what he's saying and putting references into Delphi in it, but.
And he was disappointed he hadn't found any yet. That is the professional and unbiased investigator who was chosen to lead the investigation into the death of John O'Keefe. You'll learn that one of Michael Proctor's high school friends commented to him that with a dead body on the front lawn, the homeowner in this case is surely going to catch a lot of grief. And do you know what Michael Proctor's response to that was? One word.
What's the difference between a service animal and...
Nope. And he explained why. Michael Proctor assured his buddies that the homeowner would not catch a lot of grief because, quote, the homeowner's a Boston cop too, end quote. That one sentence, ladies and gentlemen, in Michael Proctor's own words, will explain a lot to you about how this investigation was conducted. You will be able to evaluate whether Trooper Michael Proctor treated Brian Albert and his family differently because of who they are and their relationships between his family and theirs. You will evaluate whether this investigation was on the up and up. You will decide, as a result, how valuable or worthless the prosecution's DNA evidence is or is not, in light of who controlled that evidence. You will learn that Michael Proctor's fingerprints are figuratively all over this case. His fingerprints are all over the Commonwealth's evidence. You will learn that Michael Proctor showed up at Karen Reed's parents' house in Dighton to interview her during the afternoon of January 29th, only hours after John O'Keefe's body was found dead on Brian Albert's front lawn. You'll learn that Michael Proctor had her Lexus SUV towed from her parents' home. But you'll also learn that he wrote a search warrant in which he falsified the time that he took that SUV. He swore under oath that the vehicle wasn't towed until 5:30 p.m.
So, once again, he's questioning times. He's questioning the validity of the information in the search warrant. Have we heard that before in the Delphi case? Absolutely. Absolutely. So I'm gonna end it there with this video. Go watch the rest of it. I'm gonna put the link for it in the chat. But this is a perfect example of how Baldwin and Rossi can do a third-party defense even if the motion of limine is granted by the judge. And they do that by bringing in evidence of their own and by questioning the state's witnesses and getting them to admit that things were done wrong in case of the police. He says in here, we're going to bring in a snowplow guy. He's going to testify that the body was not on the lawn at this time and this time because it had been snowing that night and he went past the house. He tells them we're going to bring in witnesses and phone data that shows where Karen Reed was at the time that they're saying this body was on the lawn and she, that she ran over and left there. She left him there to die. And the snowplow guy says there was no body there and she was already home. So this is all still possible. Now, will the jury believe it? Can the defense actually prove that Richard Allen didn't have anything to do with this? All depends. And I'm going to say it all depends on, because we have not heard the state's evidence. Many trials happen where the defense tries to prove the state wrong, and the state's evidence is just too abundant. And no matter who they bring in or what they bring in for witnesses or specialists, it can't disprove what the state has proved in the case. Juries are getting smarter. They're listening. They're following the evidence. You know the rule of if a jury comes back real quick, it's a guilty verdict. The longer they stay out, that means the person's getting acquitted. That rule has been out the window for years. Juries now take their time. They go through all the evidence. They talk it through. And then they make their decision. And hopefully, in a couple weeks here, less than 2 weeks, we're going to see this start to happen in the Delphi case. Does anybody have any questions for me? I do still have hope it's going to trial in 2 weeks. But like I said in the beginning, a lot of times these motions are heard in a hearing, as I read in the beginning, but they can happen during the trial. And knowing Judge Gull's track record of having hearings, she's not going to have a hearing on this. She's going to make her rulings as she goes. Yeah, Barbara, the defense on the Karen Reed actually did a great job. Small town politics, yes. And Gloria was referring to the Tabitha Shuck Raines motion of limine. That trial, the Karen Reed trial, is going to be interesting. Now, I have not been able to watch the witnesses yet. I plan on going back and starting start to listen to that. But I've caught bits and pieces, and and I heard one comment from somebody say, "How is the defense going to counter that?" That testimony was pretty powerful. So, Gloria sounds so familiar. Yep, really does. Let's see here. Everybody's saying hello to each other. Yeah, clever wording, sanitized police report. Exactly. Okay, Lollipop, I'm missing your question. Can you ask it again? Sometimes my scroller scrolls too fast and I miss questions. Now, am I sitting here saying that the defense is going to win this? Absolutely not. Am I sitting here saying the prosecution's going to win it? Absolutely not. How can I say that? I don't know what the prosecution has. And everybody in Indiana who's going to be going to this court, to this trial, is going to have to take good notes for all of us who can't be there. Oh, okay. And let us know what all this good evidence is between the prosecution and defense, since Judge Gull is not letting cameras in the courtroom. Crock of shit, as far as I'm concerned. All right, everybody. That is it for today. I don't even know what today is. I gotta apologize. I had a fever earlier today. My husband brought it home, and I'm trying to get through the day, and I believe we are in for some eye-opening evidence too, whether it's by the prosecution or the defense. All I know is this, and I keep saying this: the prosecution would have never arrested, or I should say, the prosecution would have never brought this case to trial if they didn't feel they had enough evidence to convict him. They don't waste money like that. If they're iffy on their case, they'll make plea deals. So far, we haven't heard of a plea deal in this case, which means the prosecution is confident they have enough to get a conviction. Yes, and if they didn't have enough evidence, the prosecution, I mean, he wouldn't be in jail. He would have never been arrested. They would have never let the police arrest him in the first place. We have heard lately that there is DNA. Hennessy made a mistake and let that slip. What it is, we don't know. There's also a reason that they want the second interview with Richard Allen tossed out. He made statements in that interrogation that they don't want the jury to see. What are those statements? And now we're hearing, that when it came time for him to confess during this time, it wasn't just one or two people. It was a lot of people. So this theory that everybody is just throwing around, that is for Richard Allen saying, oh, he just was joking and he just said, yeah, I did it. Yeah, I did it. Well, apparently not. Not if multiple, and I'm talking more than 20, are saying that he actually confessed to murdering the girls. Oh, Mark, so good to see you in here. Glad you're listening. Everything that the defense wants thrown out, I believe, is obviously compelling evidence. Yeah, they don't try to throw out crap. Funny how the defense wanted to have Libby's phone evidence thrown out, and now they want to use it as evidence. Exactly. This defense team, to me, in the Delphi case, has been playing games from moment one. Absolutely have. And the prosecution is just laid back and let them play their games, throw out their information. They're not happy about it. Okay? They are putting them up on contempt charges because they're trying to scoot around the gag order and all that. That's fine. But that's their job to do that type of thing. But in reality, they're sitting back laughing at the defense team. You go ahead with this foolishness. When it counts, we'll bring it. That's what the prosecution is saying. And let me tell you, they better bring it. They better absolutely bring it. Nick McClelland and his associates on that prosecution team are going to have to be on their A game, especially with this defense team. I will be back this week with more information. I'm going to keep following the documents that keep coming out on the Delphi case. I'll be having discussions. I'm going to do, in the next week and a half, a review of the case for anybody who doesn't know a lot about the Delphi case. We've got viewers from Guilty of Crime that have joined us and other channels, and they don't know a lot about the Delphi case. So we'll be doing a review for anybody who needs to know more about the case. I will be doing Elijah View coming up here. I have a list of things. I'm going to talk about the Sadie Robinson case, which is out of Milwaukee, where remains were found. There was an arrest made. They're still looking for the rest of her remains. I'm going to be talking about the Kansas Moms case. That's a big one that's happening, and that's going to continue to happen. And there's more missing individuals that I want to profile, and a lot of updates that need to be done on cases that we have done and featured on this channel. So I'm probably going to just have one big update show, and if it's 2 hours, 2.5 hours, update all the cases, and at least you'll know what's happening. But that's what's coming up. Please remember, subscribe, click the like button, join the membership. We had our first members live, and I'm going to keep going, and we're going to keep having membership only lives. So, yes, Queen of Ocean, you said Marv like you had a question before I leave, so I'm just giving you that chance. And once again, we are a fan-funded channel. Any donations sincerely help do many great things for these families. And we still have Tabitha's story that we're going to continue with. Oh, just been listening. Okay. I'll be back. Today's Tuesday, probably tomorrow. It's probably going to be a Tuesday, Wednesday, Thursday, Friday week for me for lives. We're going to just keep going and plugging away at all these cases that are happening right now. And if you're interested in the Karen Reed trial that I showcased here, we can do some conversations on that trial too. So, thank you for joining me, and I will see you tomorrow. Bye. Have a good night. Thank you for watching Beyond the Evidence. My own opinions and analysis. I gave you my own opinions and analysis. Your own research. Inform your own conclusions. If you're interested in true crime and want to join me on this journey of discovery, make sure to subscribe and hit the bell icon so you don't miss any of my uploads. So you don't miss any of my channel. Join our membership, and if you have any suggestions for cases that you want me to cover, feel free to leave them in the comments below. Thank you for watching, and remember, thank you for watching, and remember, this is Beyond the Evidence, and I'll see you in the next video.